Good afternoon. My name is Jeff Berman. I'm one of the shareholders at Berman Fink Van Horn. Two of my law partners, Ben Fink and Ken Winkler, will be the presenters today. Briefly, many of you know all the services that BFV provides. I just want to be sure you do know. We have a corporate practice, employment practice, commercial real estate, and commercial litigation. And the commercial litigation has an emphasis on restrictive covenants and trade secret protection. And that's part of what will be covered today. This is our third office hours webinar. The first one dealt with employment matters. The second one dealt with business operations and real estate matters. Today, we're going to focus on trade secret protection and employment agreements. A few housekeeping matters. Please use the Q&A tab on the control panel if you have any questions. Please do not raise your hand, and also do not use the chat if you have a question. Our goal is to hold this to 45 minutes, and we're going to do our best to be good to that time. So first off, we have Ben Fink. Ben, you ready to go?
I'm ready. Thanks, Jeff.
Okay.
Thank you, Jeff. Welcome, everyone. I appreciate everybody spending a little bit of time with us today. This is, as Jeff said, our third office hours where we're trying to convey useful information that is helpful to you in your businesses. As Jeff said, one of the focuses of our practice is non-compete and trade secret litigation, restrictive covenants. And so I'm going to spend some time talking today about how you can protect your business now and in the future. And as we all know, the pandemic caused by COVID-19 has created a myriad of challenges for all of us in our businesses. And protecting your confidential information, your trade secret, may not be top of mind, but under the circumstances, it's more important than ever. And the reason for that is that when you have so many people working remotely, your information, the competitive edge that you've got in your business, that is in part due to the information that you've got that's confidential, that your competitors don't know, that the general business community doesn't know, are at greater risk. So I'll just briefly talk about what we're going to discuss, and then I'll get into it. First, we'll talk about what are trade secrets and why are they important. And then we'll talk a little bit about what trade secret theft can cost, who is stealing trade secrets, why you should consider relying on trade secret protection as opposed to some of the other intellectual property protections that are available, such as patents and copyrights and things of that nature. We'll talk a little bit about how trade secrets can be stolen and by whom, what strategies you can employ to protect trade secrets, particularly in a situation where many of your employees are working remotely. And then we'll talk a little bit about what you can do if trade secrets or confidential information of your business are taken by either a departing employee or someone else. And then last, we'll talk about some new developments to consider when you're thinking about how you're going to go about protecting trade secrets in your business. So let's start out, and I know most of you are not lawyers, so I don't want to spend too much time on the legal issue, but I think it is important just to briefly talk about what are trade secrets. There are really two main areas where trade secrets are defined. One is under state law. In Georgia, we have the Georgia Trade Secrets Act, which is very similar to the trade secret statutes that have been adopted by just about every other state in the country. And then more recently, we've got a federal trade secret statute called the Defend Trade Secrets Act. And there's a couple key components of the definition I just want to talk about here. One is that in order to be a trade secret, information has to have independent economic value from not being generally known or not readily ascertainable by proper means by the public. Obviously, something that is in the public domain is not something that is secret, and therefore it can't be a trade secret, and it also has to have some economic value. And then the second part of the definition, which we'll talk a lot about, is that is the subject of efforts that are reasonable under the circumstances to maintain its secrecy. And that's really the critical piece, and the thing that most businesses, most companies get tripped up on when they're looking to protect their trade secrets, particularly when someone has left and stolen information, or there's been some infiltration where information has gotten out, and the business needs to go into court to try to protect itself. So just briefly here, let's talk about the types of information that can be trade secrets. And it's really just about any kind of information that meets the two requirements we just talked about, but that is valuable to your business. It can be financial, it can be scientific, it can be procedures that you've got, plans, formulas, designs, you name it, just about anything. And one of the things we'll talk a little bit about is customer information, information about customers or clients in terms of their contact information. That's a little bit more of a gray area, maybe more of confidential information, but it's also something to think about, because for many businesses, that is a critical piece of information to the success of the business. So let's first, before we get into the details, let's talk a little bit about what trade secret theft can cost. As you can see, just from some of the statistics we've got here, this is a big problem, and it's a huge problem whether you're a small business or a Fortune 50, Fortune 100 company. Trade secret theft, confidential information leaving businesses and being misused by either former employees, former partners, or in some cases by foreign governments can cost not only an individual business a lot of money, but estimates are that the losses to the economy as a whole in the United States is extremely high. In fact, there are many studies that indicate that you really can't measure the actual losses, as many are either never reported or aren't quantified. But the question is, who's stealing your trade secrets? The primary place where the primary way trade secrets get stolen or confidential information gets stolen is by what we call insiders. Those are employees who either are leaving or maybe aren't even leaving, but they're stealing information for the purpose of working on the side or competing in some way with your business while they're working for you. But as I said, increasingly, there is theft from foreign governments, particularly China and Russia. As you can see from some of the statistics here, we don't have as current statistics as we'd like that are available, but a significant amount of the prosecution at the federal level is based on folks from China, from Russia, stealing information. And this is much more common than you think. I'm guessing if we were all together in person and I asked for a raise of hands how many people in the audience have experienced some kind of theft from their business of information, I'd get a fair number of hands raised. Unfortunately, it is something that is very prevalent, and we could talk about the reasons why. I think that there are a host of them. But the important thing is that it is very common, and of people that responded to a survey indicating that they had taken information, 40% said they planned to use it in their new jobs. And you can imagine in most instances that's in some competitive fashion. So why is it being stolen so readily? Of course, more technology creates more opportunity. Back in the days when I started practicing law, and my partner Jeff, who's got a few years on me, started practicing, it used to be that the really secret information was locked away in a file cabinet. And it was a little bit easier to protect that information and who could have access to it. You can have keys, you could have doors that can lock and things of that nature. But as we all know, technology changes everything. And between smartphones and tablets, portable drives that can store information, cloud storage, it's very difficult to find and stop technology or information theft. And as technology has developed, litigation in this area has increased. So I mentioned briefly that in the Defend Trade Secrets Act, and I think it's important just for some context as to, again, why this issue is so important and what's been done about it. In 2016, President Obama signed the Defend Trade Secrets Act into law. It was really the most significant expansion of federal intellectual property law in 70 years. And the key is that there was a federal trade secret statute, but it could only be enforced by the Department of Justice at a criminal level. And the Defend Trade Secrets Act created this federal statute that allows for civil enforcement of theft of trade secrets. So you now have sort of this two-pronged regime where you can either proceed under state law. As I said, just about every state in the country has adopted some form of the Uniform Trade Secrets Act, or you can proceed under federal law. But for purposes of today, the definition of trade secret and what you need to do to protect your information is virtually identical under both. So why consider relying on trade secret protection rather than, for example, seeking a patent or seeking a copyright? First is that you don't have to register with any federal government, with any government agency. Trade secret exists and you don't have to register it like you would with a patent. You have to apply and be granted a patent application. With a copyright or a trademark, you have to register them and have them approved. The other is that a trade secret remains a trade secret as long as it remains secret. It doesn't expire. The best example, being here in Atlanta, we love to use the Coke formula. The Coke formula is the quintessential trade secret. It's something that can't be patented. It can't be protected by copyright or trademark. And everybody knows about the famous vault that's downtown where it's supposedly kept. The fact that the trade secret, that the Coke formula has endured for as long as it has, probably over 100 years, as a trade secret is one of the examples that we use. In fact, when I'm in court arguing for a plaintiff, saying to the judge, look, judge, this employee stole this information. This stuff is secret. It's just like the Coke formula. And then when I'm on the other side and I'm defending, very often I'm in court saying, well, look, judge, this isn't the Coke formula here. This is just run-of-the-mill business information. Everybody's aware of it. So the Coke formula gets a lot of play in this space, but I think the most important thing to take away is it's a great example that a trade secret never expires as long as it remains secret. Now, the downside is that it's easy to lose. You can't put, often say this in court as well, you can't put the toothpaste back in the tube. If someone takes your trade secret and either uses it or discloses it or publishes it in some fashion, you may have some recourse, legal recourse against that individual or against that entity, but your trade secret is no longer a trade secret. It's now out in the public domain and you've lost that protection. So what do you need to do to protect your information? And first is you have to understand the threat. We've just talked about that. Then you need to consider what information in my business would really be harmful, would be harmful if it got out. What do I need to make sure that I'm protecting? And so what you want to do in the rush of your day and obviously with all of the other priorities in your business, one of the things you've got to think about is taking a step back and figuring out what information do I have that I really want to protect? Because without knowing what information it is you want to protect, it's very difficult to protect it. If you say everything we have in all of our computer systems and all of our cloud storage is a trade secret, we've got to protect it all, you may suffer from inertia because you're not going to be able to impose the kind of protections on all of that information that you would like. So you want to develop a plan, just like anything else. You've got to think about this and come up with your plan. And then obviously you've got to, once you have a plan, you've got to keep it up to date by keeping pace with technology and preparing for vulnerabilities. So I mentioned this briefly, but one of the reasons that this is so important is that in order for information to be accepted by a judge as something that is a trade secret, it has to be the subject of efforts that are reasonable under the circumstance. stances to maintain the secrecy. So for example, if you've got 1,000 employees in your business and everybody has access to the information that you consider to be the secret sauce, it's going to be much more difficult for me to go into court and say to a judge, this stuff is a trade secret. One of the other things the other side is going to say, Judge, everybody in their company has access, right down to the receptionist, right down to the folks that clean the floors. And so you have to make some reasonable efforts to maintain the secrecy of the information. So the starting point for doing that is to figure out, like I said, what is it that you're trying to protect? An inventory of the information allows you to ensure that the company's competitive information is considered a trade secret. You want to determine what confidential information, what processes, what other data give your company a competitive advantage that you want to be sure is protected. Identifying the information and where it resides also allows you to develop stronger protective measures. We just went through this with a biotech client of ours. Obviously, they've got their R&D folks. They've got folks in the finance department. They got folks in sales. They've got regulatory people. You want to go department by department to figure out what information does each department have that you consider to be confidential. And there's going to be different levels of information that you consider to be important. And you want to start with the most important. In the biotech context, obviously it's in their R&D group that it's most important they be able to protect that information and maintain it as a trade secret. And the other thing that identifying and inventorying the information allows you to do is identify opportunities to profit from trade secrets. You may have something that you haven't thought about, that there may be an opportunity to license it or to sell it that could be of value to somebody else. So part of the process is to develop a plan. Like anything else, you want to be sure that you've got a plan. And one is the plan should be in writing. Like most things, if it's not in writing, it's unlikely it's going to be followed in a way that is productive. And then you've got to think about how you're going to either segregate the information or limit the access to the information. And that's important for two reasons. One is it allows your protective measures to be more narrowly targeted. But two, it's necessary to prove that the information constitutes a trade secret. Again, if anybody who can log into the company's system can access information, there's a decent chance that that information is not going to be considered a trade secret if someone steals it or takes it with them to a new employer. So you want to limit the access on it to a need-to-know basis, especially for your most sensitive information. Just like you wouldn't allow everybody in the company to have access to your payroll information. You can't allow everybody in the company to have access to information if they don't need it to perform their job. Another thing to do is, if you have the technological capability and the budget, is to find ways to track who accesses information. Many of the systems that you have will do that for you without you even knowing it, but for many of them, that doesn't occur unless you either put on a setting that allows it or that requires some additional software. For example, a great example where we see this is with Salesforce. So many businesses use Salesforce today to track their leads, track their customers, and so many other things. And it's a fertile area for someone who's leaving to go to a competitor to go poking around in Salesforce to try to access information, maybe download it and take it with them. And this is something that Salesforce, depending on the level of your license to Salesforce, will allow you to track who accessed what information, when, what they did with it, whether they downloaded it, whether they printed it, and things of that nature. But it's not automatic. You've got to pay for that, or at least you have to have that as part of your package. And this is an example of an area where during a pandemic like this, when everybody's working remotely, it's critical that you've got control of your information. You know who's accessing it, you know where it's stored, you know what's happening to it, so that if something happens, you're able to move quickly and try to protect it. The other thing is marking information. In the old days, again, when I first started practice and you had documents that were considered to be confidential or a trade secret, they'd be marked in red with a big stamp that says confidential or trade secret. That's a little more difficult to do technologically, but there are plenty of ways to do it. You can have watermarks, you can have, again, areas of a system that if someone goes to access that area of the computer system, there's a pop-up that says, hey, you're accessing the super secret information. Remember, this is confidential. And maybe even have them acknowledge and reaffirm that they understand that's what they're getting into at that point. But there's also digital labels that can track materials, like I was saying with Salesforce, but even beyond that, there's capabilities within Microsoft Word and Excel and Adobe that if you really want to track information and make sure you know who is accessing it, where it's going, you can do that. Another key component is having written agreements. One of the first things that a judge is going to ask if I'm in court saying, Judge, this employee stole our trade secrets, you need to stop them. They're going to say, well, do you have a written agreement where the person acknowledged they'd have access to confidential information and trade secrets, that they agreed not to use or disclose it if they ever left? That usually is Exhibit A to the complaint. It's Exhibit A in court, and it's something that's really critical if you don't have written agreements. It can certainly be incorporated into an employment or independent contractor agreement, but it's important that you have something in writing. And beyond just non-disclosure or confidentiality agreements, you can consider, do you need a non-compete agreement? Is somebody in a position where if they left and went to a competitor, even if they didn't take physical information or electronic information, that they have enough information in their head that could really do harm to you competitively as a business? And if so, having a non-compete that would prevent them from going to work for a competitor for some period of time may be something that's needs to be considered. Now, in the middle of a pandemic, when massive numbers of people are losing their jobs, judges may be a little bit more skeptical or unwilling to enforce a non-compete, particularly if there's not a really good business case for doing so. But if someone is, again, if they're in the R&D department, if they are somebody that has written your source code, if it's somebody that really has access to truly confidential or trade secret information, you're going to be much more likely to convince a judge that a non-compete is reasonable and appropriate, and the person should not be allowed to go work for a competitor, and that the non-compete should be enforced. And then non-solicitation of customer covenants, non-recruitment covenants, those are ancillary covenants that can also not necessarily directly protect trade secrets, but certainly protect confidential information, keep people from taking customer information and then going to a competitor and stealing your customers or trying to recruit your employees. So in addition to a written employment agreement or a covenant agreement, you want to make sure that there are acknowledgments. For example, most companies on a periodic basis require people to acknowledge that they've read the employee handbook. It's a great idea to have a provision in your handbook that talks about confidential information and trade secrets and what an employee's responsibilities are in that regard, and have them acknowledge that periodically.
Hey, Ben, I want to just bring up a point on handbooks. We do a lot of handbook drafting for clients, and I always get the question, like, why do we need to sign non-disclosure agreements and all these other agreements you spoke of? We have a handbook. And I think one of the things that I want to stress to everyone is do not rely on a company handbook to enforce your rights to protect your trade secret information if you're in court. This is just one of those areas where it's really important that you demonstrate that you take your protection of your trade secret information very seriously, and you took certain steps. And courts, as Ben mentioned before, are very interested to know whether employees signed an agreement, not just a handbook. And also with handbooks, you all recognize that most of those have a disclaimer, at least one, sometimes more, that make it very clear that the handbook is not intended to be a contract of any type. And that administratively, you always have to track down the acknowledgments to the handbook. So just one of the points I just wanted to make here was to recognize that it is very important that if you want to protect your trade secret information and do the things you need to do to ensure that you can enforce your rights to protect against unfair competition, I would advise that you have agreements in addition to your employee handbook.
Yeah, and Ken will talk more about exit interviews. I mean, just one, periodically having people acknowledge, but then making sure when someone's leaving that you've asked, do they have information? Ken will talk more about that. And that relates to training and culture. You've got to train your employees. You got to create a culture that respects confidential information, that people understand. One of the things that I've found fascinating, it's there's a professor at the University of Florida Law School who's done a study on this and written a paper. The younger generation of employees, if you want to call them millennials or whatever the term is, they tend to have very different views, and it's a generalization, of course, to say that, but they do tend to have different views about ownership. If they create something, they view it as theirs. And it's important for people to understand that if they're working for you, working for your business, and they create something that is related to the business or connected to the business, that the business owns that. And that may seem intuitive to many of us, but for many workers, it's not. And I don't want to pick on the millennials, because I've seen people in their 50s, 60s, 70s who steal information and say, hey, I wrote that, I drafted that document, or I created that spreadsheet. I should be allowed to take it with me. And it's sometimes when I'm defending a trade secrets case, I'll ask the company employees that I'm deposing in their deposition, well, tell me, when did you actually tell people in the company that you considered this confidential or trade secret, they can't take it with them? And there's crickets. They just have never done that. So it's something that's important, whether it's formally or informally, to just have that culture and create that culture. Physical security, that's an easy one. Going back to my comment about the filing cabinet, you got to make sure that things are locked away if they are in hard copy. You got to have restricted access if there's a part of the business where the R&D is going on, or there's super confidential things that are happening, everybody in the company can't have access to that. Same with network security. We could spend hours talking about cybersecurity and cyber defenses. It's important to protect from threats from the outside, from China and from Russia. But equally as important is to protect from threats from the inside, and making sure, again, that people can't get into parts of the network or the system that they're not supposed to. Ken, is that your exit interview? I guess, I'm sorry, I'm gonna skip through the exit interview real quick, and Ken will talk about that more in a minute. Another thing to think about is your devices. There's the BYOD approach, where everybody brings their own iPhone or their own cell phone, is great because people get to pick their phone. It's less equipment for the company to keep track of. The company avoids large equipment costs, but it's important to think about the other side of that, which is it puts confidential information and trade secrets at risk. And there are certainly apps like Mobile Iron and others where you can control the company information that someone accesses on their own device. But if you're going to let people have their own phones, then it's important to think through these issues and make sure that you've covered that possibility. On another sort of related issue, it never ceases to amaze me when a salesperson leaves, and the company comes running to me and says, hey, you got to stop him from soliciting all of our customers. He's taking all of our business. And what I find out is that the salesperson has his or her own cell phone. They own the phone number, and every single customer has that cell phone number and calls them all the time. So the person doesn't have to solicit anybody. The customers are calling him or her, and he says, oh, I'm now at XYZ company. I can still fill your order. I can help you out. And he hasn't had to solicit that business. A much better approach, if you want to incur the the expense and the time that it takes is to have the company own the cell phone. So when that person leaves, the phone has to be turned in. And that's sort of what this next slide talks about is the company-owned, personally enabled devices. It certainly makes it easier to control the data that's stored on the device, easier to provide support. The downside is employees don't like it. They want to have their own device and they want to have the company reimburse them or something like that. So it is a decision to be made, but again, it's one you should be thinking about rather than just having it happen by default that everybody has their own device. And then last, before I turn it over to Kenny, is hiring considerations. So we've been talking about, the risk to you as a business of people leaving and stealing information. But the other thing is the risk that you incur liability, that you end up on the receiving end of a lawsuit if you hire somebody that has stolen information, taken information, and brings it to you and starts using it in your business. So, we recommend in the interview process, as you get further along with a candidate, having that conversation, saying, hey, do you have any information in your possession? If you do, we need to make sure you return all of that to your employer when you leave. We don't want any of it. We don't want you to bring anything to our company. And we don't need or want your former employer's information. We compete fairly, we compete on a level playing field, and we don't want to be accused of taking information or using information that we shouldn't. So with that, I think I'm going to turn it over to Ken, who's going to talk about some other employment issues, particularly ones that are front and center in light of the fact that we've got this pandemic going on and that we've got a lot of people working from home, a lot of mass layoffs and all kinds of other employment issues that have kept Ken busy over the last few months. Kenny?
Thanks, Ben. And just going back to the exit interview issue, one easy way that doesn't cost you anything to try to protect trade secrets from leaving your place of employment is the exit interview. This is a great opportunity to ask very pointed questions to your departing employee about whether or not they may have information at home or in their car or an electronic storing device. Many times employers at an exit interview might just ask, hey, do you have anything? Or they remind the employee you have to return information, and they leave it at that. And you really should do more than that. And I think if you ask several pointed questions to a departing employee, you might go a long way to find out that someone actually has information that belongs to you. And it might alert the person who inadvertently might have things and doesn't want to take it unfairly. It reminds them that they have to search and return information. So a couple, easy questions to ask any employee when they leave is, do you have any hard copies? Especially employees that have worked somewhere for a number of years. Do you have hard copy documents at house, in your car? Look for it. Remind them of their obligations to do a diligent search and return information that belongs to the company. Ask whether or not in anticipation of leaving, they might have sent personal emails, company emails to their personal email account. We know through litigation, many lawsuits that people in anticipation of leaving often will send company data, client lists, financial information to their personal email address. Ask those questions. Ask whether or not the employee has downloaded any information in recent weeks onto a thumb drive or some type of external drive, and you might be surprised what the person reveals, and that's a great way to stop the flow of information at that time. And even if the employee lies, if it turns out that they did take the information, then when you go to court to try to get an injunction, that's going to be really persuasive evidence that the person acted intentionally, and it's necessary and it's appropriate to issue an injunction against them. So just want to add that, again, it's often overlooked, but this is an important, easy step employers can take to protect trade secrets from leaving the company. On to sort of the COVID-19 now, current issues. A few months ago, I did a webinar on COVID-19 employment issues. There have been a lot of developments since then. I just want to touch on a couple things. Many of you in anticipation of company slowdowns, have already implemented salary reductions. And unfortunately, with the spikes that we're seeing now, it's possible that if you haven't already imposed salary reductions, it's something that you might have to do. And one thing I don't want you to make a mistake on and not to overlook is some of your employees may have employment agreements in which there's protections in there against salary decreases. One common term is a good reason provision. A lot of executive employment agreements have a clause, it's called good reason, where an employee is allowed to terminate the employment relationship and obtain severance money if there is good reason. And one of the terms of good reason typically is a decrease in their base salary. So it's very important so you don't trigger unknowingly some severance obligation to look at your existing employment agreements, and before you implement any salary reductions, look for that good reason clause. Also, in offer letters, you might have provided a notice provision that before you terminate an employee, even without cause, which you have the right to do, you still are obligating yourself to provide a certain amount of notice. And if you don't provide that notice, then you might be liable for back compensation for breaching the employment agreement by not paying for the notice period. So again, in anticipation of possibly having to make salary reductions, definitely look at your employment agreements and your offer letters and make sure that you're not violating some of the simple terms in there that obligate you to provide notice or severance if you make a salary reduction. Then you can go to the next slide. There's been a lot of changes as COVID-19 evolves. The EEOC has been very active in informing employers and employees about what's permissible and not permissible when it comes to testing and making sure that the workplace is safe. We know for several months now that the EEOC has blessed the use of COVID-19 testing to screen the workforce, and you can require employees to do that. Recently, though, the EEOC, and this is very important to understand the distinction, they came out and said in one of their guidelines that you cannot require employees to go through antibody testing and rely on that as a screening mechanism. The EEOC has if you go to their website, you can look at their publication and they will explain the differences between these types of tests. But for now, in the time we have, I just want to alert you, you do not have the right as an employer to require antibody testing as a screening tool. As people start to re-enter the workplace, there's been a lot of issues and a lot of problems. Obviously, people testing positive is a major concern, and everyone needs to review the CDC guidelines to make sure you understand what to do if an employee does test positive. But one of the practical problems I think a lot of you might experience in the coming weeks is what happens when an employee tests positive. It's the employee reaction to that. And this caught my eye a couple of weeks ago. I'm a big sports and especially a tennis fan, and the #1 player in the world, Novak Djokovic, had a charity event in Europe. And what happened there was some of the players tested positive. They had to cancel the event. It was very unfortunate. And they had great intentions in having the event. Again, it was for philanthropic, charitable reasons. That's great. But the players there engaged in behavior that really wasn't very advisable. They went to nightclubs at night. They played pickup basketball. And the night before the event was canceled, they went to a nightclub and were drinking, dancing with their shirts off, etc. And it caused a lot of scrutiny and bad feelings when people tested positive and they had to cancel. A lot of finger pointing. So I just want to alert you to this and think about that. You can't control what people do really outside of the workplace. Everyone has sort of their own personal risk factors and how they feel about things and the activities they engage in. But when employees test positive in the workplace, just anticipate that there might be a lot of finger pointing and a lot of hostilities that you're going to have to deal with, and understand that retaliation can be an issue. Again, EEOC has some guidelines and recent publications talking about what to do to prevent harassment and retaliation. But this is just sort of an issue I want to bring to your attention. make sure you're aware of it and anticipate that these issues might arise in your workplace, and certainly seek out guidance if these arise and you need some help. And finally, I want to alert you to what could be a really major development in Georgia to protect individuals and entities of all types. It's the Pandemic Business Safety Act that's been passed in our state legislature. It's awaiting signature from the governor. So it's not yet law. And that's really important to understand. It's not yet law, but it looks like the governor is going to be signing this in the near future. This is a very important piece of litigation because essentially what it does, it insulates entities from being sued unless someone is able to demonstrate that they engaged in really gross negligence. So it says no person or entity in Georgia can be held liable for a COVID-19 liability claim unless the claimant proves gross negligence, willful and wanton misconduct, or reckless or intentional infliction of harm. That's really good news for employers if and when this passes. The act also creates a rebuttable presumption that a claimant or an employee assumes the risk of contracting COVID-19, where the business owners take certain steps. And one of those steps is going to be posting a sign at your place of business. So this is an important development. Pay attention to when it gets passed. We are certainly going to put out some e-alerts and notices to all of our clients about this. Definitely track this litigation. This could be very important to help protect your business from customers suing you and employees suing you. But remember, the standard is gross negligence, reckless behavior. And so I'm stressing to you then, in order to get the benefit of this act, like always, it's very important that you follow CDC guidelines, you pay attention to governor's executive orders, and you put and follow the steps that they recommend, because if you don't, again, cardinal rule in HR is having policies is great, having rules is great, but if you don't monitor and enforce them, you're going to be susceptible to not meeting this standard. So again, pay attention to this, draft policies, implement them, but equally important is enforcing and monitoring your policies once you have them in place.
Okay, everybody. Ben, Kenny, thank you very much for the presentation. Both Ken and Ben covered a lot of material today. If you have any follow-up questions, please reach out to them and they will do their best to respond. We want to thank everybody that did participate today. And at the end of this, you should be receiving a survey. If you could take a few minutes to complete the survey, we would greatly appreciate that. And also on your screen will appear a host of helpful COVID-19 resources that our office has put together. Again, we think that'll be very helpful to you. And I guess finally, hopefully we will have another office hours in the near future. We'll be sure to let everybody know. Again, thank you for participating. We hope it was very helpful to you. Take care and stay safe.
Thank you.
Thank you.